Good day to all our viewers. My name is Vedika Kakar, and I am a journalist for JURIST. Today, with us, we have Professor Carlton Larson, who is a professor at UC Davis. Professor Larson is a scholar of American constitutional law and Anglo-American history. He is one of the most cited authorities for the law of treason. He has written 2 books on treason, A Citizen's Guide to Law, and The Trials of Allegiance, Treason, Juries, and the American Revolution. He's also a graduate from the Yale Law School. So, hello, Professor. We are really glad that you're joining us today. We can see your book in the background. How are you doing today?
Good, thanks. Happy to be here.
So, when I was reading your book, I was really interested in the law of treason because it came across as a very different type of law. And I read a lot of your articles and your podcast on how the treason law, even though it's one of the highest crimes in the state, is still one of the crimes in which people are the least acquitted. Would you want to talk about that?
Sure, and you're absolutely right. You know, in terms of something as a crime that lawyers think about, treason is not one of them. It's a sort of a rare crime. It's kind of an unusual crime. It's not one we see in the courts a lot, certainly in the United States. But it is something that people talk about colloquially. I mean, people sort of toss this phrase around all the time about who is a traitor or who may have committed treason. And so there's often quite a very large gap between kind of sort of popular colloquial understandings of the term, but then when you actually dig into the law, particularly in American law, which has, I think, sort of a number of odd features to it, it turns out the law is in many cases quite different than what even sort of a lawyer's intuition might have about what that law is. So that's one of the reasons I wrote the book, is sort of to help explain both to lawyers and probably even more importantly to non-lawyers, you know, how does the law of this play out, and you know who really is a traitor and who is not.
So how would you explain the definition of treason to like an audience which consists of both lawyers, students, and those who have no idea of law? And how would you sorry, please go on.
Oh yeah, so essentially every nation has some law of treason. And at a very broad level, it's the crime of betraying the nation. You might say there's typically sort of internal and external aspects. So the internal aspects would be sort of trying to overthrow the government from within, is typically a form of treason. And then externally, sort of siding with the enemy in a time of war, or aiding other countries at a very, very broad level. Those are sort of the things that are typically considered treason. Now, some countries go even much farther, say any type of disloyalty, any criticism of the government, anything that doesn't smack of 100% loyalty is potentially treason. So some countries really have potentially quite draconian treason laws, while others have laws that are much narrower. And part of the reason some of those countries have narrower laws is a concern that this is a type of crime that can often be abused. That it's very often used by governments to go after dissidents, to go after political opponents, and that's I think a mistake.
So how would you differentiate treason from like espionage or disloyalty over here?
Yeah, so I can tell you the answer, at least under American law. And so under American law, we have treason defined in our Constitution. And so it's stated in Article 3, Section 3, that it's limited to levying war against the United States or adhering to their enemies, giving them aid and comfort. And so when we're talking about adhering to enemies, that has a very precise definition, and that is it's essentially foreign nations or groups with whom we're in a state of open war. And so that means for it to be treason, you have to be aiding someone with whom we are in a state of war. And that's fairly easy if there's a declared war, like World War I, World War II. I think it's also pretty straightforward even for an undeclared war. Something like Vietnam was clearly a state of war. The Taliban in Afghanistan were in a state of war with the United States after the invasion of Afghanistan and so forth. But if it's a nation that we're not at war with, and you give them aid or assistance, then that's just not treason. But it can be prosecuted as something else. And that something else often is espionage. So for example, so if you pass secrets from the United States to another country, say Canada or France or Israel, a nation with whom we're not at war, that's not treason. That would be espionage, and could be prosecuted as such. I think the best example of this comes from the early 1950s, during the Cold War, where the Rosenbergs passed American nuclear secrets to the Soviet Union. And we were clearly in the Cold War with the Soviet Union, but importantly, it was a Cold War and not a hot war, and therefore we weren't technically in a state of war with the Soviet Union. They couldn't be prosecuted as traitors, even though everybody, including even the judge at the trial, sort of tossed off this word traitor very colloquially. But it couldn't technically be treason, at least under American law. In some countries, it probably would be, because they might have a broader understanding of treason, but at least under American law, it wouldn't.
So you've also called treason a constitutional quicksand in your book. Why did you call it constitutional quicksand, and why is the law of treason so seldom applied?
Yeah, so I term it constitutional quicksand because it's one of those things which it's very easy to sort of start talking about and thinking that you know the answers of what something must be the case. And then you actually dig into it and you discover that's not true. And so it's actually the US Supreme Court that had warned about this. It said, that this clause is full of danger. We should not trust sort of broad interpretive generalizations, as the more you dig into it, in some cases, the harder and trickier it becomes. And so you can find yourself sort of in this pit of quicksand where you thought you were sort of on stable ground, and then all of a sudden it starts sinking beneath you. I mean, I'm sure that's a feeling many lawyers have when working on particular cases, but I think it's particularly true in the case of treason. And so I guess the question was, why is it not prosecuted so much?
Yes.
Yeah. So one answer simply is that it's actually not committed that much, at least in the United States, given the narrowness of the definition. We thankfully don't have too many instances where people are actually out levying war against the United States or adhering to our enemies. Now, historically, that hasn't always been true. If you sort of think of the American Civil War, you had hundreds of thousands of people waging war against the United States on behalf of the Confederacy, and all of those people were technically guilty of treason. Ultimately, none of them were convicted for that. And I think that there was partly a sense that at the end of the war, we wanted national reconciliation. We wanted to bring people back. We didn't want just to create a bunch of Confederate martyrs if people had been hanged. And so even the trial of Jefferson Davis ultimately fizzled out. He was the president of the Confederate States of America. And even he ultimately received a pardon, and so did not end up facing trial. And so I think there's a sense that it's a political crime. And you see this a little bit in the American Revolution as well, where people who were accused of treason just weren't hanged in the way that they could have been. And the logic of the law said that they had committed the highest crime known to the law. But at the end of the day, I think juries who had to enforce this viewed it as a political mistake. That is, this person was different than a murderer. They were different than a burglar or somebody like that. They were simply a friend or a neighbor, or somebody who had made the wrong choice. They made the wrong call on a difficult political question, but they were ultimately redeemable, and that they probably didn't deserve to die for having made that choice. So,
like you explained, that most juries do not convict people because they were someone's brother or friend. But then in your book, there's also this case of Hippolyta Salazar, the only person who was ever properly convicted of treason, who wasn't even an American, in fact. He was there was this Mexican war and it was invaded and he was convicted. So, and then again, we realize how it's a political crime. So do you believe like Salazar's prosecution had somewhere racist undertones or extremely political undertones?
Oh, I think almost certainly were racist undertones with respect to that trial. And this trial is absolutely extraordinary. And I'm very excited to be able to include it in the book, because it's the first time that a treason scholar has actually written about this case. It was entirely unknown to treason scholars until my book. Historians of the American Southwest were familiar with it, But for whatever reason, treason scholars had consistently stated that no person had been executed for treason under the United States Constitution by federal authority. And that's simply wrong. Hippolyta Salazar was convicted. And what happened was in the Mexican-American War, the United States invaded Mexico, militarily occupied one of the provinces of the Republic of Mexico, which was called New Mexico. And the military commanders on the ground said, oh, by the way, you're now part of the United States. You're all citizens of the United States, and anyone who fights us is a traitor to the United States. And that is flat out wrong. That is not the law then, it was not the law now. It was still part of Mexico under military occupation. And you don't get to just invade a country and then say anyone who resists you is a traitor to you. And that makes no sense at all. But that's what happened. And so Hippolyta Salazar was then convicted of treason against the United States and executed. And he was, as you note, he was a Mexican citizen, tried in the Republic of Mexico for treason against the United States, a country he had never set foot in. And you have to think if he had been an English-speaking white person, that this probably would not have happened, right? Instead, he was a Spanish-speaking Mexican citizen. And I will say, to its credit, the United States Congress, when they learned about this, were utterly appalled and realized that a serious miscarriage of justice had happened. They demanded explanations from the Polk administration, which sort of very lamely said, well, yeah, technically it wasn't treason, but he was a bad guy. He should have died for something or other, but don't get hung up on whether it was technically treason or not. But except that actually does matter a lot. If it's technically not treason, then he was an innocent, legally innocent person, and he died for a crime he did not in fact commit.
Yeah. So like the Hippolyta Salazar case, you've also mentioned this case of Tokyo Rose in your book, who was a radio broadcaster. And when you mentioned the word resistance, something which strikes me is freedom of speech and expression, which is a very protected right in any democratic country. So till how much of something is freedom of speech and expression that transforms into resistance can also transform into treason? Because speaking against your own government, is that treason? Speaking in favor of government you are in war with, is that treason?
Yeah, so that's actually a very hard question. So American law certainly protects freedom of speech very aggressively. And I think even in the 1700s, when the treason clause was drafted, part of it was meant to be that it simply is not treason to be critical of the government. That if you criticize, even our war effort, for example, that isn't treason because it's not actually levying war against the United States and it's not really giving aid and comfort to the enemy. Now that said, there are some things you can do just with words that constitute treason. And I think the cleanest case of that would be passing intelligence to the enemy, right? You write a letter to the enemy and you say, here are a whole bunch of our military secrets. Well, that's just words. But that's, I think, clearly an act of treason. It would be strange to say that freedom of speech protected someone from doing that. And then it came up in the case of these World War II radio broadcasters. You had a number of American citizens who broadcast propaganda for the Germans or the Italians, and all they did was talk. But what they did was the propaganda was aimed at American troops. It was pro-Nazi propaganda, and they were tried for treason. And the courts ultimately said that's not protected by the First Amendment. And I think what's really key to those cases is not just that they weren't just in the United States spouting Nazi propaganda. They were actually in the enemy capital, working for the enemy in direct coordination with the enemy. And I think it would be very strange to say that type of behavior is something protected by free speech. That really does just cross a line where we say that is so unacceptable that really does amount to treason, even if you only use words to do it.
So in these cases, like the Hippolyta Salazar case or the Tokyo Rose case, do you think the court has applied a test of malice, like if there was an intended malice on the side of the people? Because in a number of cases, like you mentioned before, where they were not convicted, even though they were supporting the British, but in cases where they were not even supporting anyone and they were just in their own country, or they was probably in Japan and working for Japan, has a test of malice been applied, or has any test been applied to say that, okay, this is treason versus this is not?
Yes, yeah, so that's sort of a very murky area of the law. And certainly, I think if you do the act of treason knowing purposefully, yeah, that is, you have the purpose, say, to aid the enemy, or you have the purpose of trying to overthrow the government, that's clearly treason. And I think it's probably the case if you do it knowingly, even without the necessary purpose, that it's probably subject to treason law as well. If you do it recklessly or negligently, however, I think that's probably not covered. At least that seems to be my reading of the cases. And it's a little hard because the cases that discuss this are all fairly old, and it hasn't sort of directly come up. Exactly what the mental state you have to have, there's a little bit of a gray area. Now, most of the cases are pretty clear. When you're sitting in a radio station in Berlin, and you're shouting out all this Nazi propaganda, it's pretty clear that you're doing that with the intent to aid the enemy. The Tokyo Roast case was a little bit trickier because this was a person, American citizen, who ended up just sort of trapped behind enemy lines purely by chance at the start of World War II, where the start of the war between the US and Japan. And so she ended up serving as a broadcaster on Radio Tokyo, mostly introducing musical selections.
Yeah.
And as far as we know, she never really broadcast propaganda of any sort. And when the Justice Department initially looked into her case after the war, they concluded there was nothing there. There simply wasn't any treason. But then she was later prosecuted a few years later, and the witnesses who came forward later recanted their testimony, and she was ultimately pardoned. But she did end up spending about 6 years in federal prison. And that was a case too, which almost certainly was tainted by racism. She's tried before an all-white jury in San Francisco. Prosecutors use their ability to peremptory strikes are called to remove jurors. They use those to remove any jurors who weren't white. And so it certainly, in retrospect, looks like a serious miscarriage of justice.
I've realized that all of these trials, they become a racist, political, and also media trial to show the government's point of view. Is it the conservative point of view? Is it the more liberal point of view? It's also like to put out what the government is thinking and what the party is promoting. So going on the political side, we were also thinking that treason is a very hotly debated topic for the American courts for so many decades. And in the case of Aaron Burr, who was the vice president of the United States, Justice Marshall said that it is supposed to be the most unpleasant case of treason before the court. Could you shed light on the significance of this part of American jurisprudence?
Yeah, sure. So this is an exceptionally interesting case, and Aaron Burr is probably most familiar to worldwide audiences as they've seen the movie Hamilton. He's the person who pulls the trigger at the end and kills Alexander Hamilton in a duel. And at the time, he was the vice president of the United States. He was dumped shortly after the duel, and so he was not part of the presidential ticket in 1805. And so he went off into the American West and did various things. And what he did is really one of the great mysteries of American history. But according to President Jefferson, under who he had been the vice president, he had been up to some seriously no good behavior. And it's the most serious charge was that he had tried to plot against the United States to raise a military force to sever parts of the Western United States, create an independent country where he might be the emperor. And so he was actually charged with treason by the Jefferson administration, and he was tried in Richmond, Virginia. The trial was presided over by Chief Justice John Marshall, the Chief Justice of the United States Supreme Court. This was back in the days when Supreme Court justices heard cases on trial as well as on appeal. And so it was a very long trial, and it was an intensely unpleasant trial, as Marshall noted, because here you had the former ex-president, the guy who 2 years ago, or 2.5 years ago, was the vice president of the United States, the highest person ever charged with treason, put on trial by the administration under which he had previously served. And so it was a long, drawn-out trial. Marshall made some key rulings. He said, first of all, conspiracy to levy war is not levying war, and therefore is not treason. And so if all you can show is a conspiracy, that's not enough. Then he also held that, levying war, there had to actually be some use of force, some assemblage of men, some force that actually happened. And essentially the government was unable to prove that. And so more or less under Marshall's direction, the jury acquitted Burr. And his marshal's understanding of levying war continues to sort of shape our law going forward. And so Burr then spends the rest of his life sort of in quiet obscurity in New York City, where he continues his practice as a lawyer until his death in the 1830s. And so it's one of those, I mean, we remember Aaron Burr primarily for killing Alexander Hamilton, but the fact of this treason trial, I think, is probably sort of the second biggest thing that people should really remember about Aaron Burr.
I think that is why I found the case so interesting. First, it was the voting battle of everyone getting the same amount of votes. And then Aaron Burr was saying that, I might just contest for president if they vote me in. And then even when the trial came out, someone was someone's mother-in-law, someone was someone's fiance.
Right, yeah.
And then in the middle of that, it's like he also wasn't to do it with Hamilton. And I was like, okay.
Yes, it's utterly bizarre. It really is one of the most bizarre stories of American history.
And I think I wasn't getting it first. And then you also compared, you took Joe Biden and President Obama as examples to give on.
Yeah,
it was present. And I couldn't I had to make a mind map to understand, okay. So, yeah. And then I realized how it's a much bigger part of law and how it's not just, and I've just realized how much transparency has also increased in court procedures itself. I wanted to know that you have included so many cases all the way back from the years ago, hundreds of years ago to present, because there haven't been so many trials on treason and there's such less constitutional jurisprudence on this subject. How was it for you to find and go back to the cases and to go back to the archives to take out this information and to present it in the current format?
Yeah, so I mean, I love doing that. I mean, that's, I think, sort of the funnest part of my job is, digging into these old cases and, seeing how they played out and seeing the moves of the lawyers, seeing the arguments, looking at the underlying facts of the case, seeing how the juries operated, and just sort of trying to put yourself back into that world where this was happening. And so, I find that an absolute joy. And I mean, the book has sort of alternating chapters on law and then alternating chapters on history. And the history really is sort of the stories of particular trials. And it probably shows a little bit, but I think my greatest love really is in telling the stories, even more than in explaining the law, because I think the story shows so much about how these things played out in American history. And of course, you're right that we have to go back fairly far because we haven't had a treason trial in the United States since the early 1950s. There was one indictment in the 2000s of a man, a Southern California man who sided with Al-Qaeda, but he was killed in a drone strike. And so we just don't have recent trials. We have really no one alive, right? It's actually, tried a treason trial in the United States. So you do have to go back quite a ways to get to the stories and the cases.
So while researching, were there some parts of treason or some parts of law that you were utterly surprised with, or did you just learn something from your own research while writing this book?
Yeah, so a number of things. So the story of Hippolyta Salazar that I told you earlier from the Mexican-American War was one that I did not know. And I've actually said the opposite. I'd said in print in the Washington Post that no one had ever been executed under federal authority. And I said that in 2017, and I learned that was simply wrong. And I'm embarrassed about it now, but I'm glad that I at least found it before the book came out. It was actually, I think I had about a month left before the manuscript was due, and I came across that story, so I really had to scramble to put it together. And then another one that's in the book, which I was totally unaware of until I started writing it, was a series of treason trials in the state of West Virginia in the 1920s under state law. And so it's not just our federal government that can prosecute, our state governments can as well. And pretty much everybody who had written on state treason law said that it really only happened in the 1840s in Rhode Island and in 1859 with the trial of John Brown, who would have raided a federal arsenal in an attempt to try to end slavery. But there actually was these series of trials in West Virginia, and it dealt with miners who were sort of fighting entrenched power of coal mine operators in West Virginia. And they were tried for treason by levying war against the state of West Virginia. And I'd never heard of that before. it was utterly news to me. I happened to do an interview with a Pittsburgh reporter about something about treason. And then when I pulled up that person's story, they mentioned these West Virginia mine cases because they were fairly close geographically to where they were. And that's when I started looking into it. And again, historians had written about it, some very good works by historians. But for whatever reason, treason scholars had completely missed it. And so it hadn't entered into the scholarly literature on treason law.
I realized when I read the story of Hippolyta Salazar, I was like, oh my God, that's so interesting. So I went on a Google search, and the only literature I could find was actually the book and an article by you on him. So I also remember the West Virginia chapter because I remember reading it. And I was just thinking on how state treason laws can be misused. And do you think sometimes they might just contravene the central treason laws in a way? They might be against each other. Can there be a situation where a person might be supporting the center but is against the state he is in?
Yeah, so it's an interesting question. So I think with state treason law, to the extent that the state treason laws talk about enemies or adhering to the enemies of a state, that's just sort of preempted by federal law, meaning that federal law would make it inoperable because only the federal government can have enemies in the sort of the sense of foreign nations who are against us. The states themselves don't have that. So to the extent that the state treason law still is viable, I think it's in situations where you try to overthrow the state government, but without also overthrowing allegiance to the United States. That is, you just simply want to replace the government of a state with somebody else. And if you do that by force, I think there's a decent argument that counts as levying war against the state and could be prosecuted as such. And so there's sort of a fairly interesting recent case where people had a plot to kidnap the governor of Michigan. And they were unsuccessful. And so it's just a conspiracy. But had they actually done it, I think there's a plausible case that is the type of thing that might be viewed as treason against the state if you're kidnapping the governor and attempting to sort of alter the policies of the state as a result of the kidnapping.
Yeah, and that might just involve so many other convictions also except treason, because like kidnapping and then going against the person who works at the government level. So I was really intrigued by the test you put at the end, because I had so many questions in my mind while I was reading the book. And when I was reading the test, and they were very, real life examples of, okay, these questions and everything. How did you formulate the tests? And like, why did you come up with a test? Because as a reader, it was very helpful. But like, as an author, how did you think of it?
Yeah, it was just sort of those random ideas that sort of popped into my head, to try to make it a little more interesting and to give the reader some sense that hopefully they may have learned something. And so the back of the book, there's, I don't know, maybe 10 or 12 questions which sort of pose scenarios in treason law, and then ask the reader what the answer is based on what they've read. And I suppose part of that is just being a law school professor. At the end of every semester we have a test, and so at the end of the book I want to do the same thing. We should have a test, but also I think just makes things a little more interactive and hopefully a little more interesting for the reader.
And you also argued for both sides, like we need to do for an exam. So you gave both sides of the argument, like why this might be like this and why this might be like this. And some cases you said, okay, it might be like this, there are high chances of this, but it also might be like this and other chances. And I just remembered my law school professors creating a TOTS exams like this. So,
yeah, and that, sorry, yeah, but and that's exactly right, because I often tell my students, sometimes the question is easy, and it's clearly X or it's clearly Y, but sometimes the answer actually is it's hard, and it's hard for this reason, because you could argue either X or Y, and there's good arguments for both, and there's no clear answer, and so the best answer often is it's hard and here's why, as opposed to sort of being certain that it's one thing or the other.
So apart, once you've done with the book, you've written 2 massive pieces of literature on treason. Now, what would you think, should the treason law is ever going to be amended or modified? How do you think this should be the future for the law itself?
Yeah, so I don't see, at least in the United States, sort of significant amendments, just because it's written into our Constitution, and our Constitution is so hard to amend. It takes 2/3 of the states, or 2/3 of both houses of Congress, and 3/4 of the states. And if you follow American politics at all, you know that we can't agree on anything. I'm sure they couldn't agree on what to order for lunch. It's just so divided. And so making a significant change to the Constitution seems very unlikely. I mean, I do think there are some sort of technological issues that arise. One is that there's the limitation on proof. We have to have two witnesses to the same overt act. And there's very interesting questions about whether that would apply, say, to videotape evidence, or does that mean that someone who does it, say, simply by passing intelligence, by sending an email in their office, can never be prosecuted because there's no eyewitnesses to that event? That's, I think, an issue. There's also an issue that the older cases say to levy war against the United States, you have to have an assemblage of men. And the reason being that only a large group of men are in a position to use enough force to overthrow the government. But of course, now, you could have one person with a nuclear bomb, and that person is far more threatening, than 1,000 men with swords. And so, how would the law potentially confront that is, I think, something that may at some point come up, at least in the context of, various types of terrorist activities.
You, in fact, in your book also, you told us how the definition of treason in the American Constitution has developed from a very, very old definition of treason in the British times. So now you see the vestiges of it and how it's not in the current times. Like in the current times, you can probably pass intelligence to, I don't know, a Twitter channel also, if possible.
Yeah, and so this language. Yeah, and you're absolutely right. I mean, the language here is not just that it's 18th century language in our Constitution. It's much older than that, because it's more or less a word for word transcription from an English statute of 1351, which uses the same language: levying war, adhering to enemies, giving them aid and comfort. It's actually language that is over, I'm trying to do math in my head here, but 670 years old. And so the congruence of language between the English statute and the American ones means that American courts have often looked to English courts for interpretation of those phrases.
Sometimes I also felt like, while we were talking, I felt like how hypocritical it would be if, for example, I'm an Indian, it's still colonized, and if I say something against the British government, will it be treason against the British government? But why will it be if I'm an Indian citizen?
Yeah, well, I mean, that was in some ways sort of an issue that arose in the American Revolution, with our colonies, who were resisting British tax policies, and they, the British said that some things that the American colonists did was treason, and the Americans were incensed about that and said it's absolutely not treason. And so there was a lot of debate in the Revolution as to what counted as treason, and the Americans sort of pushing for a fairly narrow definition, and the British saying no. Some of the things you guys have done really have crossed the line. And of course, we were in the same colonial position in the sense that we had no representatives in Parliament, and we were, essentially, in many cases, governed, sort of arbitrarily by the British government. And to the extent that became even more arbitrary, that of course led to the revolution.
Yeah. Okay, thank you so much, Professor, for sitting here with us and discussing the law of treason and your book. Thank you so much for it.
Oh, thank you so much. Very much enjoyed it. Appreciate the opportunity.
Thank you so much.